Our next panel is Current Cases and Legislation, What's Hot? And my name's Sarah Luick, and I'm the chair of the board of directors of the Animal Legal Defense Fund. And our two next speakers will provide us with what we've been doing with litigation and legislative proposals and where these efforts will be going into the future, both state and federal developments, and how they may impact your practice in the future direction of animal law. Our speakers are both experts, and I'm pleased as the ALDF board chair to introduce Carter Dillard, the ALDF Litigation Program Director, and our next speaker is Chris Green. And Chris is the director of the new Legislative Affairs Program at the Animal Legal Defense Fund, and he focuses on securing tougher animal protection laws and in blocking bills that would exploit or endanger animals. He addresses legislation in states, within the federal government, and at local county board and municipal county levels. And Chris received his BA from the University of Illinois and his law degree from Harvard Law School. He's worked internationally in the music, film, and fine arts industry. And in 2004, the Animal Law Review published Chris's groundbreaking article, The Future of Veterinary Malpractice, Liability, and the Care of Companion Animals. This article presented for the first time a calculation for veterinary malpractice insurance with a consideration of damages beyond a companion animal's mere replacement cost or the fair market value. He's contributed a section on liability issues for the book Veterinarian Confidential, an Insider's Guide to Protect Your Pet's Health. He is a frequent lecturer on animal evaluation at law schools and veterinary colleges. Chris was the founding vice president of the ABA's Animal Law Committee and will be serving as its chair during its 10th anniversary year. He served on the board of the National Center for Animal Law. He's been an advisor to the National Canine Research Council, to the members of the American Veterinary Medical Law Association, and to the Illinois Farm Bureau. He's been an invited member to the California Veterinary Medical Association's Non-Economic Recovery Task Force, and he's been an advisor to members of the American Veterinary Medicine's Task Force on the Legal Status of Animals. Chris has also consulted on animal issues for CBS News, Dateline NBC, Science Magazine, Smart Money Magazine, the Chicago Tribune, and the Washington Post. So we've got two pretty important fellows up here, and we're going to start with Carter's presentation.
Thanks, everyone. And quick warning, mine's going to be very theoretical and 30,000-foot view of what I see as the key questions that animal law litigators are faced with these days. And then Chris is going to fill in with much more specific presentation about the state of development of animal law legislation today. The first task in choosing which cases to decide on as the hot cases involves which part of the movement to throw under the bus and not mention their cases. So the easy one are the environmental folks. They think of animal rights attorneys as sort of the awkward stepchild of the social movement world, and so no need to mention their cases. The farmed animal case question came up. Do we talk about farmed animals? Jane Velez Mitchell is coming to speak tonight, and if you all have seen her, you understand that she's into farmed animals, and nobody in their right mind would ever exclude farmed animals from a talk about cases. The other question, of course, feral cats. That community often likes to hear about developments in their area of the law, and the people focused on animals in research. It's a toss-up between which of those to exclude, and I just went with I'm going to go ahead and talk about animals in research because they tend to, the people doing that work tend to show up on your lawn with a bullhorn or burn you in effigy if you don't. So that's how I chose the cases to talk about, and I resisted the opportunity to pull out totally unknown and never mentioned cases to make you all sort of feel like dilettantes, like I had some inside scoop on the real track of animal law litigation. So these are cases you've all heard about. I want to sort of resist the temptation to just talk about specific cases in isolation. And I'd rather talk about 5 questions that I think help frame our thinking about the development of animal law. Much the way law schools don't teach cases in isolation, they generally teach you cases in a pattern to teach you how to think about the law. I'd like to think about these things as questions that we're continuing to try to answer, and that cases, unlike statutes, are resolutions of disputes. They're narratives about how disputes are resolved. So they're not giving us rules per se. We often talk about the rule of a case, but what we're also talking about is when an issue came up, came to a head, came to a dispute, that it landed in court and animals' interests were central to that case, how did we resolve that issue? How did the courts weigh the factors? And what were the values and the hierarchy of values that were used by the court? Sometimes explicitly, and in my opinion, most of the time, impliedly. So we'll talk about the values that go into answering these 5 questions, because even hardcore legal positivists that think that legal decisions, judicial decisions, are driven by the law, I think will admit that in politically sensitive areas like the development of animal law, that's when the judge's values are really going to take center stage. And so a lot of what I'll talk about has to do with the underlying values and how we rank them to answer the questions that courts are faced with. Just my overall impression about the development of animal law in the courts is that it's a very positive trend. It's a trend from one pole to another, and the direction that we're moving away from is one of the exclusive use and control of animals by their owners. So you heard a little bit about property last night. Property gets us thinking about the res, or the thing itself, the animal, as property. But really, property is just more a description of the relationship between people. And property generally refers to the exclusive use and control relationship that somebody has regarding a particular object. They can exclude everyone else from interfering with their use of that object, their control of that object. And in fact, the implication is that the object itself has no interests. They've excluded the interests of the object that would otherwise interfere. And I think we're moving away from that pole. The development of groups like the Cavalry Group, which is a legal organization dedicated to protecting the rights of persons to own animals and operate animal-oriented businesses free from attacks by animal rights extremists, tell us that they're sensitive. The legal community is sensitive to the fact that this erosion of exclusive use and control is occurring. And I think that another sign is that if you look at the state of animal law litigation today, cases in the courts, you'll realize that a lot of them are by owners that feel that their use and control of their animals are being interfered with by the state. And so they're challenging that interference, usually by constitutional means or some other grounds. So they're fighting back against the state interfering with that exclusive use and control. But I think there's a trend away from that, because it's simply, I think it's a radical proposition to say that you can equate an animal with an item over which you normally have exclusive use and control, right? My phone, I have a property interest in it, therefore I can exclude others. The phone itself has no interest. I can destroy it. I can sell the phone, put the phone in a box, do whatever I want because this phone is mine. I have exclusive use and control. To equate an animal that appears to have his or her own interests, right? They would go in their own direction given a freedom to do so. They can suffer. They can convey that suffering to us. To say that a person ought to have exclusive use and control to exclude the interests of everyone else in society, including the state, including things like animal cruelty laws, including the interests of the animal, him or herself, in order to use the creature, to exploit the creature in a parasitic way, a dependent way, where the person becomes reliant upon the animal or their business becomes reliant upon the animal, so that they're claiming their right to cause suffering so that they can just continue to exist. That's a radical proposition. I don't think the animal rights proposition is radical. I think it's radical to equate animals with things over which no other person and the animal itself would have no say, that is radical. And so I think we're moving away from that. As we move away from that, there's going, and there has been, a natural reaction in courts to be concerned about a flood of cases, like the floodgate problem. Courts have enough trouble dealing with all of the human interests that are at stake in the disputes in litigation. As an animal lawyer, you go into court, you're telling the court, there's a whole world of other species out there, Your Honor, that you're going to have to consider. So while you're underfunded, your docket's 2 years behind, and you only have 2 law clerks, I'm going to introduce an entire world of biodiversity interests for you to consider. And we've seen that in the cases we'll talk about. So while I think there's a positive trend, there is an inevitable backlash by courts that are concerned, and the natural inclination when they're concerned is to simply say this is a legislative matter. So whether or not there's law on point, judge-made doctrine will arise, tricky things like standing that wasn't there before, prudential standing, constitutional standing, curious interpretations of statutes, the result being to exclude animal cases from courts, odd doctrines like equitable abstention, which is simply the court saying, for a lot of reasons, I'm simply not going to hear the case. So there's a positive trend, but I think my one piece of advice to animal litigators is be sensitive of the floodgate issue. And if you are bringing a case to court, find the way to do it with the thinnest edge of the wedge that you can, because courts are very sensitive to the possibility that their dockets will explode. But nonetheless, as I said, I think the trend is positive. 5 questions, I think, and this is how I frame in my mind the animal law litigation today, the state of it. And these are the cases that I think help tell us where the law is going with this issue. Why does the legal system care about animals? Why? It's question number 1. Why does the system care? I think the answer begins with the concept of a legal system itself. And I think the most simple way to think about a legal system is as an agreement or a contract, right? We all live in a democracy, so we adhere automatically in some ways to the principles of a social contract. We all voluntarily came together or remained together, and we formed a legal system that we agreed to the underlying norms. And that agreement, that social contract, those norms, the rules, the terms of the agreement, those are our laws. Right off the bat, there's a problem, right? Animals are not part of that agreement. They did not consent to the constituting of the United States or any other country. They're simply absent from the process of contract making. I think as David Casito pointed out not long ago in a great article, that puts them in an odd position with the law because they're not part of the consensus, the discourse that we now see as our democratic legal system. So where do they fit if they're not part of it? And if we're coming together to create an agreement between ourselves as to what rules we ought to create, what are the rules of the road for how we'll interact, how do animals factor into that, if at all? What's the interest that we have in those animals? And I think that the closest that I've seen a court come to answering that question, and I think it was dangerously close subsequent to that in the Supreme Court case, but I think the Third Circuit in the U.S. v. Stevens case is a good place to start. There, the court was presented with a question of whether the state had a compelling interest in banning the depictions of animal cruelty, in that case, crush videos, right? Not the creation of the videos themselves, the underlying conduct that led to it, but whether the depictions themselves, banning the depictions, regulating the depictions in some ways, whether there was a compelling state interest. Do we care about these videos floating around that people might possess where animals are being stepped on by women in high heels and slowly killed and tortured before they're killed? And the court held, and was very explicit about this, that the state did not have a compelling interest in that other values in this hierarchy of values overtook any interest the state might have in preventing those depictions and regulating those depictions. And it said so because the interest, a compelling interest, whatever it is, it has got to relate to a human interest. It's got to relate to people's well-being, humans' well-being, and not to an animal's well-being. As I said, the Supreme Court ducked the issue, didn't deal with that particular question, but they certainly could have. and it remains out there, sort of unanswered. Now, the law, after being struck down by the Supreme Court as overbroad, was amended. Congress said, listen, there is a compelling state interest in preventing this stuff, so we're telling you next time it goes to court, and it is going back to court. It's already in the Fifth Circuit again. The new law will be decided. But in the interim, that question about why we care and do we even have an interest in preventing things like animals being, like the depiction of animals being tortured flowing around the marketplace, that remains a bit unanswered. And in fact, that decision, the Third Circuit decision, has been cited for the proposition that the state must have a human interest in mind in order to create the basis for legislation that would be of a compelling state interest nature. Enoch v. State, Florida, 2012, and U.S. v. Chamness, Kentucky, 2012, both cited Stevens for the proposition that for an interest to be compelling, it has got to relate to a human interest, and those cases interpret that to mean if there is a human interest, it's going to be the prevention of things like the development of antisocial personalities, so that animal cruelty and the depictions of animal cruelty, they are a threat to us because they make us less social with one another, and the social contract doesn't work if we are becoming hardened to one another, less empathetic with one another, less other regarding. But that's, I think, a key question. Why do we care? And at what level do we care about animal welfare and autonomy? The second question, where do animals fit in? If they're not members of the social contract that have made some agreement with us, where, if at all, are they part of the picture? Now, the normal inclination would be, well, if they're not part of the picture, the members of the contract are simply free to use them to better their interests. They become part of the economy. They become a resource that can be owned, exclusive use and control. And that question, I think, in some ways gets answered by State v. Nix. Case in Oregon, which several people in the room, I think, have worked on, involving several counts of cruelty for neglect of horses, and the question was, there's several counts of cruelty, several victims here, or is it really just one crime, one underlying crime? And there was a question about, the underlying question was, is the law there to protect the owner of the animals? So the historic idea of animal cruelty was, it's there to prevent you from harming your neighbor's animal. Is it there to protect the public, or is it there to protect the animals themselves? And the court held that the legislature's primary concern was to protect individual animals as sentient beings. So they are not part of the contract itself, but they're apparently protected third parties with some role. We have some duties to them. Third question, who does the protecting? This is, I think, one of the key questions animal law is going to have to answer, right? We know we're all in a social contract. We come together. We've made agreements. Some of the norms that we've agreed to involve protecting these third-party beneficiaries of the agreements, animals. Who does the protecting? I think there are two ways to answer this question. State versus federal. That's a key question. Is it going to be the feds? Is it going to be state actors? NMA v. Harris is the case that I think in some ways, and I think it's very specific to its facts and to the statutes in question, but in some ways, in answering the question of whether or not California could ban the slaughter of downed pigs as what I think the state viewed as a matter of animal cruelty, the court found no, that simply historic USDA regulation of slaughterhouses preempted that. So the feds have control and downed pigs can be slaughtered, dragged and beaten and pushed into the slaughter process. Doesn't always go that way. California's historic ban on the production and sale of foie gras was upheld by the Ninth Circuit recently. The associations challenged Harris again. Shark finning, again in California, Northern District of California, upheld against preemption challenges. So it's certainly not going to always side with the feds, but that question about who does it is key because it's going to determine whether it gets done at all. And given the lack of resources for enforcement on both ends, it's a key question. The second question about who does it is, I don't want to presume, and we shouldn't presume, that it's always going to be the state that protects animals, right? Historically, citizens have played a significant role in that, and they ought to play a role. So in Stop Animal Exploitation Now v. Santa Cruz Biotech, that question is framed. Can an organization that's losing money because of violations of state cruelty law, can they sue to simply enjoin the continued violations of that law? Does an organization have that authority? Or is it just the state that can stop violations of the law? Can privates do it too? Seaton v. Adams in Pennsylvania, 2012. This case hit that question dead on. SPCA officer who had authority to cite pigeon shooters for the cruelty that they were causing did so. The case was subsequently dismissed by the district attorney on grounds which everyone agreed to were legally incorrect. And the question came before the court whether or not the district attorney had exclusive authority to say whether the law should be applied or not. They held that the district attorney did, that no private actor could assist with the enforcement of these historic cruelty laws, although 3 judges dissented in that case. So why does it matter who's doing it? If we go back to the first question of why we care about animals, we ought to be thinking of a legal system that creates effective enforcement mechanisms. So I don't really care who's doing it, federal or state, private or public, as long as it's getting done. And that may, given the limitations that public officials face in terms of budget and other constraints, it may counsel in favor of more involvement by private actors, by citizens, in protecting animals. Fourth question is, we've been talking about human versus animal interests, that we're accounting for their interests as something separate, but is that always the case? Well, litigation today is showing that that is absolutely not the case, as animal law litigators find areas where there's interest convergence, where there's overlap of human and animal interests. Front Range Equine Rescue v. Vilsack was a TRO that halted horse slaughter in the United States because lack of NEPA review. And the underlying question was whether residues in the horse flesh had been accounted for in the NEPA review and the impact that that would have on humans and on the ecosystem. Regal Vegan versus Hudson Valley Foie Gras, suing foie gras producers for claiming to be humane, and therefore Regal Vegan, which produces a vegan alternative, would lose money. They would lose sales to the lies. ALDF v. Vilsack, again suing over whether foie gras is an adulterated food product, if creating a diseased animal, which violates food safety laws meant to protect humans, could be used to protect animals. These are all things that are sort of examples of interest convergence. And the question there is, are we going to have enough competitors creating vegan alternatives, enough consumers that care, enough environmental harm through CAFOs to eventually sidestep the question of whether we have to actually care about animals for their own sake? Do we have enough of our own interest to do it? Fifth and final question, are animals all the same? We've been talking now about humans and animals, non-humans and humans, as if there were just a binary divide. But I think the next group of cases will begin to answer that, and I would hazard to guess that the Non-Human Rights Project will play a role in that process when they begin to attempt to blur the line between humans and animals. And I would think that given the Cambridge Declaration on Animal Consciousness, Fish and Wildlife Service, scrapping split listing for chimpanzees, and the National Institute of Health finding that the vast majority of chimpanzees ought to be taken out of research, that even our most central institutions have begun to realize that there is a blur between humans and animals, and it might be at great apes. And that's a key question for why we care, because we care if we can't draw a line between humans and animals, if we don't know where that line is. So I'll end with just a quick observation about those questions and the cases that I think are starting to answer them. And that is, generally taking a sort of pessimistic view of it all, the law still takes the position, and judges take the position, that there's got to be a human interest at stake for them to decide the case in a way that will help, as a matter of simple consequence, animals. And that they wouldn't do it for the animal's own sake. But there's and that works fine at an individual level. We can say, listen, we need humans, a human interest at stake. We need humans not to be desensitized by animal cruelty. We need them to care because it'll impact how we interact with each other. But at a collective level, that won't work. At a collective level, for us to be other regarding, for humans to truly be empathetic, to not be selfish, to be other regarding and thinking about the other in a social contract way, there's only one way to do that, and that's to regard the interests of animals, non-humans, to be truly other regarding. It can't be just about us. That gets us back into the selfish paradigm, sociopathic paradigm of self-interest that the courts thought was the basis for the social pathologies they thought would be exacerbated by animal cruelty. So I think in the end, animal law is pushing us in a direction of being more other regarding, which in the end means that we not only alleviate animal suffering, but we eventually move towards letting them go. Thank you.
How's everyone doing? You guys enjoying the conference so far? Whoa, this thing moves. Jeepers. Yeah, it's really cool to be here. It's last night sitting at dinner with Paul Waldo and Sarah, who were the second and third people I ever met in the animal law community, sitting at Steve Wise's kitchen table. And I was taking a class with him 13 years ago, crazily to say. And I remember going to my first conference at Lewis and Clark and sitting in a hotel lobby drinking beer with David Favor, and then meeting David Wolfson and Pam Frash and all these people whose scholarship I had so admired and whose readings I just poured over when I was doing some of my own work. And just to be sitting with these people, exchanging ideas, it's just a wonderful opportunity. So I really hope you get the most out of it, and want to say thanks to Stanford Law School for putting this on, and for hosting it, and for ALDF for putting it on and sponsoring it, and to Joyce and Liberty for all the work they did getting it together. So, if I can put that there, okay. So it's interesting. People often think of litigation as being sort of fast-paced and energetic, and legislation being this sort of glacial monster that slowly kind of happens. And it's interesting because Carter's mind has this, like you said, this amazing 30,000 feet view of just really the philosophical approach of where he wants to go and explaining that. I have always have a ton of information to convey, so I tend to be this sort of cramming, 10 pounds of peanuts in a 5-pound bag and blazing ahead. So I'm going to talk pretty rapidly and blaze through a lot of this stuff, so there will be some time for questions afterwards, and I'm around all weekend, so if you do have any questions, you can just hit me up then. My program, the Legislative Affairs program, is ALDF is bolstering up to initiate and support efforts to enact stronger anti-cruelty laws and animal welfare laws at the federal, state, and local levels. Not only do we go sort of on offense, as it were, and try to initiate our own bills that will kind of positively improve the lives of animals, but in legislation, everyone also has to play a lot of defense and try and shut bills down that would, endanger or exploit animals further. We also provide free legal services for legislators by drafting and reviewing animal protection legislation, testifying in committee hearings. Last week I hit 3 hearings in 3 time zones in 7 days, and it really does work. I mean, politics is a contact sport. I mean, it's you have to be in the room to participate. So, and ALDF is also offering grants to help offset startup costs for some of the legislation we propose. And for example, in Massachusetts, there were 3, now 4, separate offender registry bills that were introduced this session. So we had a legislator calling me up saying, I can't make heads or tails of this, can you explain this? So we take the time to kind of parse out the differences among them all. ALDF also has some incredible resources, if you want more information on any of this, putting together a compendium of model animal protection laws, which are sort of our best case dream scenarios of how we think ideal laws should be written that legislators can consult and use. We also have another compendium of just an overview of all the state animal protection laws in the country. So you can go online and look state by state and look your state up and see where your laws stand. And also Scott's criminal justice program has materials on helping prosecute animal abuse cases. We also have the annual animal law protections rankings, which really does help. I've been dealing with some folks in Kentucky lately who are just like, we're so sick of being dead last. We really need to do something. This is embarrassing. It makes us look bad, and we're smarter than this, which I hope is the case. And I'm very proud of the fact that my home state of Illinois is always ranked #1, which is primarily due to a woman named Lidie Von Cavage. She was formerly at ASPCA. She's now at Best Friends. And she's a great example of how one person really can make a difference in this realm. She happened to live right outside Springfield when she was working for ASPCA. So she's like, heck, I'll just try it here first. So she single-handedly drafted and got passed 24 pieces of humane legislation pretty much on her own. So one person really can have an impact in this realm. The things that we've worked on to support in 2013 so far, creating animal abuser registries, banning the export of American horses to be slaughtered for food, preventing the unnecessary killing of predators by USDA's Wildlife Services, restricting the private possession and ownership of exotic animals, enlarging the space provided to farmed animals used in agriculture, and requiring adequate police training on animal fighting, use of deadly force, and how to better enforce anti-cruelty laws. On the defense side, because you can't really sit back, so that's why sort of legislation kind of is often in trenches, because anyone can introduce a bill, so you sort of have to react. If you don't react, it could get passed. So as you'll hear about in Matthew's presentation tomorrow, ag-gag laws were a real big issue this year. Attempts by universities to exclude themselves from publicly disclosing animal experimentation. This is a big problem at University of Wisconsin this year in Madison. They do a bunch of just terrible, terrible experimentation on primates. And so Carter's crew and PETA have been trying to get records of that. So regardless of how people may feel about scientific experimentation, it should be a public decision. And without adequate information and finding out what they're doing, we as a society can't decide whether it's valid or necessary or not. And so Wisconsin tried this year to exclude themselves based on a claim that because they're applying for patents, if they would release this information, it might allow someone else to beat them to the patent office with it. Luckily, they've got other financial misdealings, so people saw through that and it failed. And what do you know, magically 5 days after it failed, they announced to Carter's team that they're not going to comply with his public disclosure request. So pretty transparent what they were trying to do. Also sort of breed discriminatory legislation. The King Amendment, which I'll talk quite a bit further, that would prevent states from setting their own health, safety, and welfare standards, moderately important, and rules to prevent the EPA from gathering information about factory farms, and relaxation of water pollution regulations for other CAFOs. Senator Charles Grassley from Iowa, sorry. We say Iowa in Illinois, sort of like a thinking man's Iowa in Illinois, but anyway. I only say that because she's from there. So Senator Grassley from Iowa tried to introduce another amendment to the Farm Bill in the Senate that would have prevented the EPA from even flying over factory farms to see if there had been water pollution spills or anything like that. I mean, it's just absurd. So the big hot topics this year, as we said, which I'll kind of go into in more detail, we've got the state ag-gag bills, the Farm Bill, horse slaughter issue, Kurt alluded to, Wildlife Services, chimpanzee welfare, and animal abuse offender registries. So we'll start off with the big one, and this could not be more timely. They finally, well, as you know, we've at least got an operational Congress right now. I wouldn't accuse it of being functional yet, but as we're back in session now, so the Farm Bill, President Obama is saying flat out that he wants this passed right away. And full disclosure, I've managed a farm that's been in my family for about 176 years. So for the past 15 years, I've been managing that. And there are some good elements of the Farm Bill that do need to be passed, but there's also some pro-animal stuff in there about prohibiting taking a minor to a dog fight and things like that. But Stephen King, also from Iowa, got a piece of an amendment in there, which basically he calls the Protect Interstate Commerce Act. And before I jump on, I mean, this is not hyperbole when people say this is potentially the most harmful piece of legislation towards animals in U.S. history. It really is the nuclear option and could be that bad. So he calls it the PICA, the Protect Interstate Commerce Act. And basically what it would do would prevent any state from applying its own health, safety, and welfare regulations to any agricultural products produced in other states. And agricultural products is defined pretty broadly, so that could include puppies from puppy mills, milk, any animals or animal products. So essentially, this could repeal California's Prop 2 and the foie gras ban. So where California says, okay, we're not going to allow, California technically doesn't ban foie gras, they ban foie gras that's produced by the force feeding of ducks. So that's great. So what Steve King's amendment would do would say, okay, that's all well and good, but you can only apply that standard to California producers. You can't say to producers in other states that you're not allowed to produce in these less humane ways. So in California, there's nutritional requirements for milk. There's 9 different states have passed now animal confinement bills similar to Prop 2, and like I said, puppy mills. So you could say, you could do away with puppy mills in your state and get this huge victory, and all of a sudden if this passes, say, well, sorry, the state right next door can just flood your market with and that's exactly it. You end up with this sort of, this race to the bottom scenario where whomever is producing these products at the least expensive and usually least humane way, they then will set the sort of de facto national standard, because it won't take long politically when California is suddenly having its markets flooded with cheaper goods produced less humanely before the California producers go to their legislatures like, this is unfair, this regulation is restricting us, we can't compete. And then slowly, one by one, these regulations would be chipped away and we would have the sort of lowest common denominator set by whomever's doing things cheaply and least humanely. And, you know, it's somewhat hypocritical of Steve King because he's this Tea Party darling who is always screaming bloody murder about states' rights and how dare this federal government tell us what to do regarding same-sex marriage or restricting abortion or anything like that. Yet, as soon as one state wants to do something that happens to affect the largest egg producer, which just so happens to be in his home district, suddenly it's like, we need the federal government to still in and tell the state what to do. How dare they set their own standards? So it's pretty blatantly hypocritical. And he's also sort of a clown. I mean, people say, you know, Steve King are Iowa. Some people say Steve King are like Mars or Jupiter or wherever. I mean, he's on, just tune in the Daily Show, type in Steve King, you'll see a million excerpts of him talking about, you know, being pro-dog fighting, talking about Latinos having calves aside. It's just, he's just all sorts of crazy racist stuff. So people are distancing themselves from him politically, but the reality is, I mean, it's almost a misnomer to call this a King Amendment because it is now part of the House's version of the Farm Bill. So where things stand, you know, the House passes their version, the Senate passes theirs, but the House couldn't pass their own Farm Bill last year. And then they couldn't, again, pass their own, that's how dysfunctional the House is right now. They can't even pass their own Farm Bill. So what they had to do was strip out, and the Farm Bill is a bit of a misnomer. About 70% of the funding of the Farm Bill goes towards food stamps. So basically Republicans couldn't decide on how much they wanted to cut food stamps. So when it failed the first time, they just went back and just excluded food stamps altogether from the legislation. So, you know, normally that's how legislation works. Each side has something they want. The Dems want the food stamp stuff, the Republicans want all the farm subsidies, and then they bargain, they horse trade, and they go into conference committee and they come to a resolution. Now we don't know what's going to happen because the House no longer has anything to negotiate with because they just excluded 70% of the bill from, but by everyone's sort of assessment, it's going to be pretty close. So it's now down to this sort of closed room, and we know they've finally just named who the conferees are. So the stakes could not be higher. It's literally going to happen Monday or Tuesday that they're going to start meeting on this. So when you get any alerts from any organizations, don't put it off. Call immediately this week. It's that important. So the next issue, and sort of what I'm doing is kind of inverting the pyramid. I'm sort of starting off showing here's the large grand things happening at the federal level. Like I said, you know, federal government's pretty dysfunctional right now. So, you know, you can get some things here and there, but, you know, a lot of the action really happens as we'll go down to the sort of state and regulatory and county, even local city level, that you really can have a huge impact at those levels by being actively involved. So the horse slaughter issue sort of reared its ugly head again in this year, which we thought had been done away with. And in late June, USD issued permits to allow a couple horse slaughter plants to open up, New Mexico, Iowa, and another one in Missouri. And so this would be the first time in 6 years that horse slaughter has occurred on U.S. soil. My home state of Illinois was the last state to ban the practice in DeKalb, Illinois, and I was pretty actively involved in that. And we thought we'd won. This is great. That was the last operating horse slaughter plant. And once it shut down, coincidentally, around the same time, I think the case Carter referred to, DC District Court ruled that slaughterhouses could not fund their own health inspections. And so Congress stepped in and said, well, this is great. There are no currently operating horse slaughter plants, so we're just going to defund inspecting them for slaughter. So that basically became a sort of de facto sort of moratorium on horse slaughter. So we all thought this was great. However, they only did it for a few years, till 2011, thinking, of course, Congress will reauthorize the Ag Appropriations Bill by then. Then we have our current Congress, which, again, can't even pass transportation bills. Okay, transportation bill, like everybody has highways in their district. They all get a crap ton of money to fix the highways. It's the biggest pork-filled thing. Everyone loves them. Even transportation bills have been so politicized that they can't get passed in the current Congress. So what happens? Ag Appropriation Bill doesn't get passed last year. So now, all of a sudden, there's no longer a funding ban. So these 3 plants that want to open, they sue the USDA saying, wait a minute, why aren't you issuing us permits to open? There's nothing preventing you from doing so. And the USDA is like, oh, we'll get around to that, and just kind of push it aside. And after a while, the plants are like, well, we're filing suit. So then in June of this year, finally, as both houses are considering the Ag Appropriations Bill, they both houses, the House and the Senate, re-include the funding ban in there. So everyone thinks it's great, hunky-dory, this is awesome, it's going to pass in July, fine. And so the USDA says, okay, smarty pants, we'll issue your permits knowing full well that Congress is going to reinstitute this funding ban, and we'll just never get around to inspecting them. However, again, our lovely Congress didn't get them passed in time, and so all of a sudden, now USDA's sort of hands are tied, and the problem was, it then actually started an internal argument within the USDA. There are some sort of pro-horse slaughter folks within the USDA, and there's some arguments. I mean, what has essentially happened now that we've banned horse slaughter in the United States is that horses are now being shipped to Canada and Mexico, transported in just horrendous conditions, and slaughtered in ways that are worse than they were being slaughtered in the States in many instances. So there's some people who say, well, that means that, law of unintended consequences, we never should have banned horse slaughter in the first place, which is ridiculous. Just because there's a loophole in the law and people find a way to subvert the spirit of it doesn't mean it wasn't necessary. It just means you need to find the loophole and plug it. So right now, Sameen Said and some other folks who are involved in this suit were able to get a temporary restraining order. So what they did is that they then sued the USDA. So, okay, we're going to sue you as well. We're going to sue you saying you can't move forward with these inspections because, as Carter mentioned, you haven't done the due diligence research to find out if horse meat is toxic to humans because of all the performance-enhancing drugs that get added to them, and there's also huge wastewater problems as well. So now, then interestingly, the judge made them post a $500,000 bond for any potential damage it would cause to these horse slaughter plants. But it's very odd. It's one of the rare occasions where, like, I'm suing the USDA, but yet I'm having to pay a bond for these third parties over here who aren't even part of the lawsuit just in case they might be damaged. Really, people are pretty perplexed by that. So now it's essentially just a race against time if we can get the Ag Appropriations Bill passed before this lawsuit kind of comes to fruition and goes to trial. And the judge has said she wants to expedite it as fast as possible, so we'll see. There is another answer, and that's the Safeguard American Food Exports Act. Not only would this sort of wipe out the current problem and prevent new horse slaughter plants from opening in the United States, but it would also plug the loophole that I mentioned of ending the export of American horses abroad to be slaughtered for food. And last year alone, there was 160,000 horses were taken to Canada and Mexico to be slaughtered, and also to prevent the public from. So, again, it's tough right now in the federal government to get legislation passed, but this is a big issue and it's on people's minds. So if you get an alert saying, hey, look, looks like there's some traction in the SAFE Act, do everything you can to let your representatives know that you're interested in seeing it passed. Next up, I won't really talk too much about these because Matthew's going to cover them quite a bit in his talk. I'll just blaze through a couple things. Just the good news is that we were very successful this year. There were 11 ag-gag bills introduced across the United States, and all 11 of them were stopped. Arkansas is a bit of a misnomer. People think that Arkansas actually passed. They kept the name, so it sounds like it's a really bad ag-gag bill. It says only police and other authorities have the right to investigate animal cruelty. But the bill is gutted, and the only thing it says actually is that folks, if their animals are taken away by the state, they have to then pay for their care while they're taken away. So people think an ag gag passed in Arkansas, but it actually didn't. And thanks to Matt for helping with that. Tennessee's bills came close, but it was actually vetoed by Governor Haslam. This is actually my first day in a job at ALDF. We got this news, so it was a good way to start off legislatively. And that took a lot of guts. You're dealing with a southern state. You've got it passed by both houses of your legislature, ag heavy, and here you are. And in great part, thanks to his attorney general, who wrote a really good report saying that he just doesn't think this is constitutional. So I will blaze through this and let Matt talk about that. But I will mention that, as we talked about quite a bit, ALDF filed the first ever lawsuit challenging the constitutionality of Utah's ag gag bill or law. And there was some resistance to this from some other animal organizations who are saying, look, you guys have been so successful this year. You've we've got a 11-0 victory record this year. Why take the risk of having this lawsuit out there and maybe find out that these constitutional arguments aren't as strong as we're leading people to think they are and shooting this down? But I feel exactly the opposite way. The constitutional argument is but one of several arguments we have against ag gag suits, and which you'll hear tomorrow. And actually, the existence of the suit itself can have a great reverse chilling effect. So now there's some rumblings that Colorado is going to try a bill. New Hampshire's definitely sort of on the table. So our first thing is to go to them and say, look, Utah's having a hell suit out of them over this right now. Is that something you really want to bite off? Do you really want to pass something that's being challenged as unconstitutional in another state? Legislators don't really like to do things that are going to make them look bad, and so or cost them money. And this is certainly costing Utah some money and making them look bad. So, in my mind, and it's going to take probably 3 years or something for this to wind its way all the way through the courts. So, in my mind, the existence of the suit really helps legislatively because it shows that there are problems. So, those are the two big federal ones. Now we're kind of narrowing a bit further. Wildlife Services is a very interesting issue. There's people who have been working on this group for 20 years, and they're saying right now, 2013 is just sort of like, tip of the spear, that there's sort of the most activity they've ever seen on this issue. So for those of you who don't know, Wildlife Services is a division of the USDA that basically their formal name was Animal Damage Control Department. So Wildlife Services is a euphemistic thing that makes it sound like they're doing positive work. But yeah, they've killed 2 million native mammals and 15 million native birds since 2000, often on public lands, basically whenever there's a rancher or farmer who thinks they have a problem. And the problem is that they use indiscriminate methods. They have these snares, explosive cartridges, cyanide poisons, and aerial gunning. So when they say that they're exhausting non-lethal methods first, or that they're only targeting animals that have proven themselves to be a problem in targeting livestock, that's simply not true, because how do you know which animal is going to be caught in a snare or eat the poison? And the problem with indiscriminate methods is that you then often kill animals you're not trying to kill. And so you see 150 different species of quote-unquote non-target animals, including bald eagles, federally protected golden eagles, even in California condors, one of the most endangered animals in the country, and gray wolves, all caught in these things and all killed by Wildlife Services. And so their primary, the animal they kill the most seems to be coyotes. And during his tenure, Wildlife Services has spent $1 billion with a B dollars on trying to control coyotes through this lethal control methods. And during that time, the coyote population has tripled. So obviously their methods aren't working. So there's also some sort of high-profile incidents of cruelty by trappers. There's a guy named Jamie Olson, who's a Wildlife Services trapper, who has his dogs with him, and whenever he finds a coyote in a trap, he lets his dogs just maul it to shreds and then films and photographs it and posts those pictures all over Facebook. All while on the company dime, taxpayer money, paying a salary on the job. So, there's a big push there's an investigation here. USDA will still not release the results of its investigation. It's been 1.5 years, never once reprimanded. Tom Knutson at the Sacramento Bee wrote an incredible 3-part expose on this agency. I recommend you all go read it if you have any further interest in this. I mean, it really tore the scab of what they've been doing. So what's interesting is that, we've been talking about sort of larger, federal and state issues with down to ag gag, but here with Wildlife Services, even though they're a federal agency, all their contracts are actually done on a county by county level. most county board members aren't even aware of this. So day 3 on my job, we found out that Wildlife Service in Sonoma County, where ALDF is based, we found out that Wildlife Services was going to renew its contract that following Tuesday, or its contract was up for renewal at a meeting that following Tuesday. And so Carter's team had been studying this for quite a while, analyzing under public trust doctrine and the California Environmental Quality Act, saying, they actually think there's some legal problems with this if you were just to rubber stamp this. So they sent off this very scary letter saying, basically pointing out all these legal issues and telling the county board, if you just go ahead and rubber stamp this, there's huge legal problems and someone, maybe us, might come sue the hell out of you. And surprisingly, it worked incredibly well. They immediately yanked it off the agenda within days. We were all a little surprised. Yeah. And so they yanked it off the agenda, and they still haven't quite been able to parse out and come to a conclusion on the strength of our argument. So just the beginning of this month, Sonoma County let its contract with Wildlife Services lapse and laid off the one trapper that was being paid for by the government side. So it's kind of this joint thing where you've got some federal money and then the county money, and they kind of combine their money and pay for these trappers. So this is great. So now they've said it's lapsed, and they're not going to reintroduce it until beginning of the year, which is great because it now, after having Carter's big stick of going and threatening litigation, we can come in and meet one-on-one with the supervisors. And now, for the first time in 20 years, Sonoma County has a 3-2 progressive majority on the county board. And one of the 2 non-progressives was just recently arrested in his underwear trying to break into a neighbor's bedroom. So we may have a 4-1 majority pretty soon. And this is after 6 months after nearly being a man to death outside a bar in San Diego. So yeah, he's probably not around for long. But what's great is that right next door, we've got this awesome example of Marin County, where 13 years ago, they canceled their contract with Wildlife Services and instituted a non-lethal predator control program. And so now we've got 13 years of data to analyze how successful it's been, and we see predation's dropped by 62%, and it's only a third of what they were spending before to do lethal control methods. So sort of everybody wins. The ranchers are having less animals killed, the county's spending less money, and the public gets to enjoy its wildlife more because fewer of them being killed. So Marin, it's still sort of, some people are able to kind of dismiss Marin because it's Marin. It's not really considered a large agricultural community, whereas Sonoma County is much more diverse agriculturally. And so if we can kind of set a model in Sonoma, then it will be a great model that can be applied throughout the state and the rest of the country. So June of this year, and this is a great thing, this is what really attracted me to ALDF when this opportunity came up, is because you'll see from the examples I'm giving, it's such a broad spectrum of information that's subject matter. So we've got farmed animal issues, we've got sort of exotic animal issues, we've got research issues. So as Carter talked a little bit about here, in 1 month this year, both the U.S. Fish and Wildlife Service announced that they would be listing chimpanzees under the Endangered Species Act, and the NIH agreed that it would retire all chimpanzees from research and send them to sanctuaries. But sadly, as I mentioned, in University of Wisconsin, there's still a bunch of universities and private labs still doing some brutal experiments. And so ALDF, to counter that, is introducing some local ordinances to protect primates and safeguard their individual interests. We've got one that we've drafted that will prohibit invasive research, bar their use in entertainment, ban their breeding or sale, establish a guardian ad litem whenever there's an issue, and to make sure that the interest of the animal itself is the primary focus. And this is a great tool to chip away at university labs that continue such cruel, abusive research. You can focus on a town where many of these universities are based. So more good news, this awful. So this is a photograph of a Ringling Brothers training facility where you've got a baby elephant. And I don't know if you can tell that device he's got jammed in his back has about a 2-inch poker on the end of it that's now buried in the back of that poor baby elephant, as it's having one leg pulled this way, the other pulled that way to sort of get it to submit. And nearly all of their elephants wear the scars of these things called bull hooks that they use to quote unquote train them. So the good news is, just as of last Wednesday, LA decided to ban using bull hooks on elephants. Great news. Here's the actual wording. Bull hooks, baseball bats, axe handles, pitchforks, other implements and tools designed to inflict pain for the purpose of training and controlling the behavior of elephants. It's so depressing that they actually have to list each one of those things to tell people they cannot use them. They neglected to mention electric cattle prods, which also get used all the time. And so there are a lot of people who are complaining now that, well, this didn't go far enough. We really need to ban all wild animals altogether in use entertainment, or elephants. Yeah, that's great, but right now it wasn't politically possible in Los Angeles. But here it achieves, as you see from the quote from the Ringling exec, it achieves the same outcome, where he said flat out, we will be unable to bring Ringling Brothers back to the city of Los Angeles now that this ban's gone into place. So lastly, the last subject I'm going to address is the animal abuse offenders and how to prevent future harm, how to prevent people from reoffending and acquiring animals that they can harm. So one idea is to create animal abuser registries, and this is something that ALDF was at the forefront on. 12 years ago, they created a model law and added it to the compendium, and so far 3 New York counties have passed such laws, but yet they're restricted only to sort of felony abusers, and we all know how few felony convictions there are. And so there's only been 3 abusers registered so far. So we said, well, it has to be a larger level. We've got to go for cities, we've got to go for states. I testified at the New York City hearing. But 25 states have considered this so far, and yet any of them they've all failed to be accepted and passed, and primarily because of 2 main problems. One is financial. So you're asking these states to create this whole new registry out of broadcloth, pay for it themselves, administer it themselves, and usually they don't want to do it. In New York City, for example, anything that happens to animals goes through the public health department, and the health department wants nothing to do with animals, so they're like, we don't want to, and they come up with some astronomical price. I think California said it would cost $2 million to set up their registry. The closest we've gotten is Michigan, which has a bill I just testified on last week, that said basically, they said it was going to cost $140,000 there, even though ALDF had 2 different contractors saying they could create this database for under $10,000, and ALDF offered to pay them the $10,000. They still said that wasn't realistic. So Michigan's solution to this, they said, well, we already have this existing criminal history database that allows people to do background checks on anyone. So we're just going to waive the fee and require all shelters and rescues and animal control facilities to go consult this and do a full criminal background check on anyone wanting to adopt an animal. That's great for Michigan. Not all states have that, but also there's some concern that that might be going too far, that if anyone going to adopt an animal at a shelter know that they're going to be subjected to a full criminal background check, they might be less likely to go in, and that causes a whole host of other problems. So thinking hard about this, and internally, ALF is sort of announcing today, basically, that we're creating a national do not adopt registry that will administer a national database of animal abusers that anyone in the country can access. So this way, shelters, pet stores, breeders, and citizens can ensure they're not adopting or selling to anyone with an animal abuse conviction. As we all know, the horrible puppy doe incident in Boston, where this person gave their dog away on Craigslist that was then subjected to this brutal, horrible torture. And so then we'll follow this up. We're creating this now, and once it's operational, we'll then follow it up with legislation and state by state to mandate that they report their animal abuse convictions to the registry. They check the database before anyone transfers a companion animal, and it would also increasing the penalties and banning ownership of animals. So Boston's measure right now would say for 5 years, no one's allowed to own an animal for 5 years after being convicted of animal abuse crime. So this way we can make sure we have a quantifiable impact on animal welfare. And it improves the chances of passage by legislators and city councils, because now rather than asking them to go do this whole thing that they don't want to do, we're saying, hey, we've already got it here. We're just asking you to opt in. Also will increase public awareness of animal abuse and provide an effective new tool for Scott's team to sort of track animal cruelty conviction rates, so we can actually compare jurisdictions and see who needs help. So pretty much everybody wins except the bad guys. So what you can do, be involved, sign up for various different organizations, get their action alerts, and when you get them, please don't ignore them. We try to be really judicious with the ones we send out. If we're sending you something asking you to be involved, it's because we really need your help. Letters to the editors really help. And there's a lot of state groups. Texas Humane Legislation Network, Minnesota Voters for Animal Protection. There's a lot of great groups out there that are much more on the ground and can keep you in tune with anything that pops up. And so, as one legislator said, it's not enough to simply have an idea. It's not enough to show up at the Capitol with a bill proposal. It's important to build a sustained movement. And so by binding yourself together with these other organizations, you can have sort of collective bargaining power to combat the power of those who want to abuse animals further. So thanks a bunch for your time. Sorry I ran over. Talked a little slower than usual.